Shalom. My name is Michael Decker, and I'm a lawyer within the law offices of Cohen, Decker, Pex and Brosh. Today I wanted to discuss the matter of a joint life application at the Interior Ministry when one spouse is an Israeli and the other is a foreigner, as it relates to same-sex couples. There are basically two policies that are relevant in this situation. One policy deals with married couples, and the other policy deals with non-married couples who are known in public, and it includes same-sex couples. And that's really the policy that the Interior Ministry focuses on, same-sex couples. And that policy was enacted after a series of many court precedents which relate to same-sex couples. And these court precedents mainly relate to same-sex couples who are known in public. Also because only recently in the whole world did the application of the marriage institution become relevant on same-sex couples. Until recently, this was not a common legal phenomenon which existed in the world, and it is something that is still being changed and developed in Western countries. The reason I mentioned the two policies is because the policy that's relevant on known and public couples is longer than the policy that's relevant on married couples. So a married couple basically can go through the whole joint life procedure within 4.5 years. So for the first 6 months, the foreign spouse gets a B1 working visa, and then for the next 4 years, the foreign spouse gets an A5 temporary residency visa. And at the end of the process, the foreign spouse can naturalize in Israel and get red citizenship in accordance with Section 7 to the Law of Citizenship, which does not require the foreign spouse to renounce his other citizenship. Whereas the policy that's relevant to a known and public couple is longer. The foreign spouse first gets a B1 working visa for 27 months. And it should be noted that this B1 working visa does not allow and does not provide full national insurance coverage. And after the period with the working visa, then the foreign spouse gets an A5 temporary residency visa for 4 years. So after this longer period, in the end, the foreign spouse only gets permanent residency and not citizenship. And at that stage, the foreign spouse can submit a naturalization application, not in accordance to Section 7 to the Law of Citizenship, but only in accordance with Section 5 to the Law of Citizenship, which requires the foreign spouse to renounce his other citizenship, which, if we're dealing with a foreign spouse from a Western country, which is considered a quality country, like a European country, Australia, the United States, New Zealand, and etc., then most applicants in this situation will not even want to apply for Israeli citizenship if it requires them renouncing such another citizenship. The question of what policy should apply on a married, known and public couple was raised in a case called Avot Ge'im against the Ministry of Interior. Gay fathers against the Interior Ministry. In this case, the couple submitted a petition against the Interior Ministry to apply on them the policy of a married couple because the Interior Ministry wasn't willing to do so. The compromise that was reached in that case was that the length for a married same-sex couple will be the same length of the policy relevant to married couples, meaning it will be 4.5 years. But the policy that will be applied will be the known and public couple, because Israel has to accept the marriage license because of international conventions, but in Israel, same-sex marriages are not yet recognized internally. So this was the compromise that was reached. So therefore, the process is the same, the length of the process is the same length. However, the discrimination which still exists in the matter is that in the end of the process, the foreign spouse won't get citizenship because the policy that's applied is the policy not relevant to married couples, and then the foreign same-sex partner will need to naturalize in accordance with Section 5 to the law of citizenship, which basically requires him to renounce his other citizenship, which may not even be relevant to him if he holds a quality citizenship. And this, in our opinion, is not a fair situation, and it should be changed, and we'll be happy to assist with a change like this. In any case, if you have any further questions on the matter, you can feel free to contact us. Thank you for your time.